Hello, everybody. We are back with discussing the Melly trial because, as you all know, there is never a dull moment in the Melly trial. Again, we are in the middle of jury selection in the second Melly trial. As we know, the first trial for the first Melly trial resulted in a hung jury, and now we are in the middle of jury selection for the retrial. But this is going to take a while. They're probably still not even through the first phase of just seeing whether all the jurors can actually sit for the extent of the time that this trial is going to take. So we still have a little bit of time before the actual opening statements begin in the second trial for Melly. But we do get to see at least what the defense and state file in this case. So you'll recall that we last spoke about, in our last video, we spoke about the motion that the state filed to essentially bar Melly's mother from even being in the courthouse during this trial. And the reason was that they stated that there's been testimony that she is trying to tamper with the jury, and she's trying to make nonverbal communications with certain jurors, and she's standing where the jurors are supposed to be going to their cars in the parking lot, and hanging out in the hallways with the jurors, and crying into a tissue when some of the jurors are passing by. So these were all allegations that the state put in their initial motion to just bar Ms. King from even allowing her to come into the courtroom. And of course, they gave some alternative remedies if the court would so choose. And as we spoke about, it's going to be very difficult to imagine that the judge would not allow Melly's mother to be present for his trial when this trial is a first-degree murder trial, when he's facing the death penalty. So, as expected, the judge did file an order on this specific motion. He is allowing Ms. King to be present during this trial, as expected. But this is what he says. The state alleges that defendant's mother, Jamie King, had improper contact with certain pre-qualified jurors and asked this court to institute measures to protect prospective jurors from further interference relying on Smith versus State. The court hereby orders Ms. King to stay away from all prospective jurors and from any areas where prospective jurors are likely to be present at a given time. So she's not allowed to be around where the jury is around. Ms. King is ordered not to have any contact with prospective jurors, whether verbal or nonverbal. Ms. King agreed in open court to comply with the above directions. So she is allowed in the courtroom, but she is being told that she better not have any contact with the jurors, verbal or nonverbal, not be even in the presence of the jury during this jury selection, and certainly during the trial as well. So that is how that issue ended. But of course, now we have another issue in the Melly case. So as you'll remember, there was a initial motion that was filed by the defense to dismiss the entire case. This is going back a few videos. They filed a motion to dismiss the entire case. They also filed a motion to recuse the entire state attorney's office from trying this case, and to recuse the previous prosecutor, Christine Bradley, from even trying the case. And the reason is that they discovered, and this was brought out during testimony at an evidentiary hearing, that Detective Moretti, allegedly, according to this witness, who was a over 20-year prosecutor who was present when this happened, she testified that Detective Moretti was investigating alleged witness tampering by Melly and Melly's mother. And Melly's mother was giving a statement with her attorney present, and Detective Moretti served a search warrant on Melly's mother. And the problem is that Detective Moretti did not have jurisdiction where he was to be able to serve that search warrant. If you don't have jurisdiction to serve a search warrant, then any information that you get from that search warrant is not going to be admissible into court. And the testimony was that Detective Moretti served the search warrant, and the only way that it would be permissible is if there was a deputy in the room that did have jurisdiction in that area. Then he would be allowed to serve the search warrant. However, the testimony was that the deputy was not in the room. And only after the deputy returned to the room and Ms. King, Melly's mother, and her lawyer already left, did Detective Moretti tell this deputy, I'm going to need you to say that you were in the room when I served the search warrant so that it will be a valid search warrant. So essentially he's soliciting the deputy to lie for him. And because of that, and the defense has made an argument that they didn't even find out about this till after the first trial. They didn't find out about that whole situation until after the first trial, and certainly the state attorney's office knew about it, and Christine Bradley knew about it, and they didn't let them know about it. The prosecution, the state did not let the defense know about it, and then they have a duty under Brady, and this we all discussed in previous videos. You can go check them out, but we discussed that they have a duty under the Brady law to be able to notify the defendant of these type of actions that are taken. and they were not notified, and therefore they moved, first of all, for the dismissal of the entire case. That was number one. And, because who knows? It could be if they had this information during the first trial and they brought it out in that trial, maybe Melly would have got acquitted. So maybe a dismissal is appropriate and warranted. So that was number one, that they asked for a dismissal. Number two is that they asked to recuse the entire state attorney's office from trying this case because they argued that it was all the way up, all the way to the higher ups who knew about this and were not disclosing this information. And number three was to recuse Christine Bradley, and the judge went for the last thing. He recused Christine Bradley from trying this case. And part of the main reason for that was not as a sanction or something, but it was because now it opens the door for impeachment. Because now Detective Moretti is going to be testifying during this case. He's the main detective, and the defense is going to try to impeach him with, first of all, as we've already heard in the first trial, that he already was threatening people and threatening to deport people and all these different types of threats he was threatening people. And on top of that, now they're going to be able to say that, look, you asked the deputy to lie for you so that search warrant would be good. So that's another level of impeachment that they're able to bring out. And in order to bring that out, they would have Christine Bradley also testify. So the prosecutor can't prosecute for the state, can't be a lawyer and a witness at the same time. And therefore, the judge recused Christine Bradley from trying this case because now she's listed as a witness. Okay, so that's where we left off. And now, with that issue. But now the defense filed a motion. I think the defense filed a motion. They filed on October 29th. And their motion was that now they want to take the deposition of Detective Mark Moretti. Now, generally speaking, a deposition is a discovery tool. You take depositions of witnesses that are going to be testifying during the actual trial, and you want to get a feeling for what they're going to say before. And therefore, you're allowed to take their deposition, and then you're able to use the transcript. And that's what we always see in trials, where if someone's testifying, that they always say, well, do you remember giving a deposition in this case? And they present them with the deposition transcript, which could be contradictory to what they're testifying to now. So a deposition is a discovery tool. And what the defense is arguing, the defense for Melly is arguing in this case, is that they should be able to take another deposition of Mark Moretti. Of course, they took a deposition before the first trial, but then they found out about all this extra stuff, certainly about the soliciting the deputy to lie for him. So they filed this motion, a very short, basically page-and-a-half motion, and they really argue, they make two reasons why they should be able to take this Detective Mark Moretti's deposition again a second time. Number one is that they cite to the Florida Rule of Criminal Procedure 3.220H, which states that you are allowed to take a second deposition of somebody. Generally speaking, you only have one shot at it, right? You only take one deposition, but you could take a second deposition if you show to the court good cause. If you have good cause, why you should be allowed to take a second deposition. They're arguing that we certainly have the good cause in this case. First of all, the main reason is, as we've just spoken about, is the fact that they just found out now about this soliciting a deputy to lie for him. But number two, they also argue that in reviewing the testimony, I'm going to read it straight from their motion. In reviewing the testimony of Mark Moretti, there are serious discrepancies between Detective Moretti's testimony, and they're referring to the testimony that he gave about the cell phone data and the tracking data and the Google exhibits, and that testimony. There's discrepancies between that testimony and the actual evidence which were provided by Christine Bradley. So there's now that they went through the first trial, they have all these questions for Mark Moretti because they saw that certain pieces of evidence that Christine Bradley offered into evidence actually was contradictory to some of the testimony that Mark Moretti gave. So now we just found out this now after the first trial. So now they want to be able to ask Detective Mark Moretti in a deposition before the trial about all these discrepancies. So two reasons why they want to take another deposition. Number one, the soliciting the deputy to lie. They want to ask him all about that. And number two is they also want to ask him about the cell phone data, which supposedly his testimony contradicted some of the evidence that Christine Bradley presented in the first case. Okay, pretty simple motion. They rely on one rule of criminal procedure. What is the state's response to this? The state filed a response. This is October 30th. So this is the response that the state argues. Number one, they argue that defendant's motion is legally insufficient. It fails to provide any legal basis as to why redeposition should be permitted. It's merely conclusory and fails to demonstrate the good cause as required under the rules of criminal procedure. So they're saying you didn't provide any legal basis. All you did was say that there's good cause, but you failed to demonstrate it. So as we know, as a lawyer, part of your job is that you have to ask the court to do certain something. That's what's called a motion. A motion is when you're asking the court to actually, very, very like its meaning, to get into motion. You want the court to do something for you. And if you want the court to do something for you, you've got to, as a lawyer, not just ask the court, hey judge, I'd like for you to do this for me. Well, why should the court do that for you? You, as a lawyer, one of your main jobs is to be able to provide the authority to the judge in why what you're asking for, he has the authority to grant. So you're asking him to take this deposition. You, as the lawyer, have a duty to show the judge why, in this situation, the judge has authority to grant what you're asking for. So they did cite to a rule of criminal procedure, but generally speaking, you usually like to not just rely on one rule of criminal procedure. You like to bring other case law and other opinions which show similar facts to your scenario and apply it. Say, look, you see that this decision in this court, they felt that this judge felt that what I'm asking for is appropriate, and it's very similar facts to the case in front of us today, and that's why you should grant this. But the defense's motion only relied on one rule of criminal procedure, and that's one of the arguments, one of the attacks that the state is attacking on the defense motion, is that you didn't really bring any authority. You just stated one rule of criminal procedure that said that, if you have good cause. You didn't show any case law that shows that there's similar situations that occurred in other cases that where the judge granted a second deposition or anything like that. So that's number one that they're arguing. Number two, they argue, they say, I'm just going to read it for you. It says, now the defendant also wishes, they're going to discuss the cell phone data. The defendant wishes to redepose Detective Moretti in regards to the cell phone, to the cell tower location, information, mapping, and data generated from health records. This information was available and had been disclosed prior to his first deposition. You want to ask him about all the cell phone data and everything like that? Well, we already provided all that to you before his first deposition, so you shouldn't be able to take a second deposition about that information. And then they say that the defendant failed to inquire upon those issues is not the responsibility of the state. So, you failed to do your job. It's not our responsibility to now let you have a second crack at the apple and take a deposition again. You had all this information before, and you failed to ask him those questions. But as you recall, that wasn't the defense's arguments. The defense's arguments was that it wasn't that they would want to ask him about how he knows about the cell phone data and Google exhibits. The specific argument that the defense makes is that we saw evidence during the first trial which contradicted what Detective Moretti was talking about. That's what we want to ask him about. So this argument really just doesn't really make so much sense. It doesn't address the argument the defense is making. So that's number one. But to the state's credit, they do come back to this. That was what they first argued. And then they say, well, the defendant makes a vague, they don't say, well, that was just me. The defendant makes a vague allegation in regards to discrepancies between his testimony and the actual evidence, but offers no specific allegation, example, or offer of proof. This also does not constitute good cause. So now we actually come to a legitimate argument. Okay, the argument is, okay, you're saying that you need to take the deposition of Mark Moretti because it's contradictory to some of the evidence that Christine Bradley presented in the first trial. That's the argument, right? Okay, so you want to say that's the argument? Well, you didn't bring any examples. All you just said was just one broad statement. Well, there's discrepancies. Well, what discrepancies? Why don't you tell the court, give the court one example. Give us just one example of what the discrepancies are. And then, okay, maybe the judge can say, that's a good example. And you can say, well, there's many more examples, but we don't want to, file pages and pages and pages of exhibits. We're just giving you a few examples, but they offer no examples. So that's one of the things that the state is arguing. This is actually a pretty decent argument, saying that's not good cause just to say a broad conclusory statement, there's discrepancies. That's not going to cut it. You got to give us some concrete examples. So that's the first attack against the defendant's request for another deposition. Now, this gets into the better stuff. Now, the better reason why they want a deposition is because of the soliciting the deputy to commit perjury. So now they say like this. They say, the defendant also contends that Detective Moretti solicited the BSO deputy to commit perjury. However, Detective Moretti is not currently under investigation by any agency for alleged misconduct. So you're trying to say that he solicited a deputy to commit perjury? Well, he's not under any investigation from any agency about performing any of these acts that you're alleging that he did. Okay, well, he doesn't. It's not the greatest argument, because at the end of the day, there was testimony in front of this judge that the judge heard from a prosecutor who's been doing this over 20 years, who said that that's what happened. So if it's serious enough for this court, it doesn't matter whether internal internal investigations are done by any agencies for this misconduct or not. Okay, but that's an argument that they make. Well, he's not under any investigations by any agencies or internal affairs for this alleged misconduct that he engaged in. Okay, not the greatest argument. Now let's move on. Further, this is another argument. Further, any testimony in regards to any alleged attempt to solicit perjury is not relevant to the case at hand. So, you're going to now, you want to take a deposition, right? This is the state responding to the defense. You now want to take a second deposition and you want to explore all of this about soliciting the deputy to lie. Well, what was he soliciting for him to lie? Even if we would accept your allegation as true, that you want to that he solicited this deputy to lie. What was it in regard to? Did it have anything to do with this case? It had to do with a search warrant that he was giving, a search warrant that he was serving on Melly's mother that had to do with witness tampering. That doesn't have to do with the murder charge in this case. What does it have to do with the murder charge? That had to do with a witness tampering, a separate charge, and nothing to do with this case. So they're saying it's not relevant. The whole issue is not even relevant. And then he says, Detective Moretti's alleged conduct in a separate criminal investigation in 2022 is unrelated to this defendant's 2018 case. What he did in 2022 has nothing to do with the 2018 murder. Nothing to do with it. And then they quote a bunch of case law that stands for the proposition that general acts of misconduct are inadmissible as impeachment evidence. And that's true. General acts of misconduct. So let's say you have a witness on the stand, and the witness is testifying about something that he observed. And now you say, this is what you want to impeach you want to impeach this witness. You say, you have a bunch of speeding tickets, don't you? Well, what does that have to do with the case? That's just a general acts of misconduct. That has nothing to do with the case. So you can't just say, oh well, we heard that you were a very poor student. What does that have to do with anything? That has nothing to do with the case. So just saying bad acts is generally inadmissible. So they're saying, well, it's just a bad act that he tried to get a deputy to lie. That's generally inadmissible. And then they bring some other things that are inadmissible, also similar to bad acts, but not so much relevant. So here's what they say. Because the information demanded by the defendant is legally inadmissible and irrelevant based on the case law and statutes as noted above, there's no legal basis to redepose the witness. Further, it is anticipated that the defendant seeks his deposition in order to potentially impeach Detective Moretti. This is what's known as collateral impeachment. So now they're coming into another legal argument, and that is that collateral impeachment is not either admissible. Now, what's collateral impeachment? So first of all, we spoke about the bad acts. Bad acts is just somebody does a bad act. That's not admissible to impeach the witness. There's also something called, well, let's say the witness actually testified about a certain fact that has to do with this case. They testified about something that actually has to do with this case, and now you want to impeach that witness about a specific fact that he testified about. But that fact is really not material to what's really going on here. It's not material to the main issues of the case. And you just want to poke some holes in something, so you want to just impeach him on some fact that has nothing really, that's not really material to the case. That's called collateral impeachment. Collateral means it's not so important. So this is what's referred to as collateral impeachment. You want to now, what's the state arguing? The state's arguing to the defense. You want to now impeach Detective Moretti by some way that he solicited a deputy to lie for him with regards to a search warrant that has to do with witness tampering for Ms. King's cell phone. We're here for a murder trial. What does it have to do with a murder trial? It's so collateral. It's so little to what it's so not important to what the main fact here is about the murder. That's what the material issues are in front of us. What does that have to do with the murder? So the other argument is that this is known as collateral impeachment, and collateral impeachment is also not admissible. And then finally, the last argument is that further, the evidence remains inadmissible. This last argument is what the last resort for all attorneys. This is just the last resort when you're in trial and you have nothing else to argue. This is what you argue. Further, the evidence remains inadmissible if the prejudice outweighs the probative value. Really, if you think about it, all relevant evidence should be able to come in. Anything that has any sort of relevancy, anything that's relevant in the slightest, should be able to come in as part of the trial. Because at the end of the day, it does have some relevance. It does have some significance in proving one thing or the other. So anything at all, it's a very, very broad category. Anything that has any relevance at all should be allowed in. However, there is a limiting rule, and that is where there is a danger of prejudice, where if the prejudice is going to outweigh the probative value, then you're not allowed to admit that even if it's relevant. So now their last argument essentially is like this. Even if you want to say it's technically admissible, it's not a bad act, not just a general bad act. Even if you want to say it's admissible and it's not collateral impeachment, still, when the jury hears this, the danger of prejudicing the jury against Detective Moretti unfairly outweighs the probative value of what you're offering, the fact that he made this deputy, or he solicited this deputy to lie for him. So whatever probative value, whatever value that's going to bring to the case to show that Detective Moretti can't technically always be trusted, and sometimes he doesn't, sometimes he does some interesting things, that point should not be admissible because the prejudice is just too much. It's just too much prejudice, and the jury's just going to forget about all the facts, forget about all the evidence, not care about anything, and just judge Detective Moretti based on that instance and just ignore everything else. So that's the last argument. The last argument is that even if everything's admissible, well, it's just too prejudicial. It's too prejudicial to be admitted into evidence. And that's the last argument. Now, the main problem with the state's response, there were some good points, like I said, but what I think a very big problem with the state's response is that there is already an order signed by this judge. Right? They're filing this response in front of this exact judge. And this exact judge wrote an opinion when he was recusing Christine Bradley. I remember the whole basis for him recusing Christine Bradley is because of this impeachment issue, that Detective Moretti is now going to be impeached, and he's going to be impeached by using Christine Bradley and testifying about what happened over here with this deputy. And in that order, in that opinion, this is what he says. This is what the judge says. The state argues that Ms. Bradley's testimony would be inadmissible at trial because it would constitute inadmissible impeachment on a collateral matter. This is exactly the argument that we just went through, that this is collateral impeachment. And therefore, they made the same argument when it came to Ms. Bradley testifying. The state wanted to strike Ms. Bradley as a witness because it's just a collateral matter. And therefore, she should not be able to be called as a witness by the defense, and therefore she should be able to try the case as a prosecutor. And the judge rejected this argument. So the judge already rejected this argument when it came to Christine Bradley. It says, the state argues that Ms. Bradley's testimony would be inadmissible at trial because it would constitute inadmissible impeachment on a collateral matter. The court is not persuaded by this argument and finds that any testimony, this is the judge himself. The court is not persuaded by this argument and finds that any testimony concerning Deputy Moretti's purported statement to Deputy Gorell, which is the deputy, inducing him to lie about being present during the execution of the search warrant, is material and falls within the exception to the collateral impeachment rule. So the judge himself is essentially, in his order, before the state even filed this motion, said, letting everybody know that this is not considered collateral impeachment. And yet, the state is arguing that in their motion, in their response. So, what can the state possibly be thinking? Well, the only thing that I can imagine that the state is thinking is that, well, maybe the judge will reconsider. Maybe the judge will reconsider. Now that we're going to show him all this case law and bring some other examples about similar situations, maybe he will change his mind. The chance of that happening are not that great. Right? The judge thought about this when he wrote this motion. When he wrote this opinion, I'm sorry, and he clearly feels himself that this is not collateral, and it would be admissible, and that's why he recused Christine Bradley. I guess what the state would want now is for the judge to now reconsider everything, and then be able now perhaps to even reinstate Christine Bradley to be able to try this case. Because if he rules that this is really collateral impeachment, so then now Christine Bradley cannot testify, and now she can go back to being the prosecutor. So whether the judge is going to grant this motion for the defense's motion for a second deposition, Mark Moretti, I don't know. I'm not saying that the judge is certainly going to grant that motion. It could be he feels that there's still not good cause. It could be that he'll feel that, you know, it's just one discrete area, and you can go ahead during the trial and discuss that with the detective Mark Moretti, and therefore you do not get another deposition. You know, is there basis to allow a second deposition? Probably. There's probably some good cause to allow the second deposition. But I'm just saying that this argument that the state is responding to by saying that it's not admissible, all these arguments are not admissible, the judge already said it's admissible. So it's not really going to fly, in my opinion, that those arguments. Again, I'm not saying that the judge is not going to grant the motion, or he is going to grant the motion. I'm not saying what he's going to do. He could go either way, but I'm just saying that those arguments are just not going to be so persuasive, I believe, on this judge. Okay, that will do it for now, and looking forward to next time. See you next time.